Good morning, everyone in Business Law 1. This is my second attempt at putting a video up for Chapter 12. Got almost all the way through the material and the computer crashed and didn't save anything. So let's give it another shot and hopefully it works. Chapter 12 is about third-party beneficiaries. And some people find this a little bit boring, but it is an interesting concept. And there's a lot of these issues do come up in practical business experiences. At one time, we didn't recognize third-party beneficiary contracts. What do I mean by all this stuff? Define it, Jim, right? Third-party beneficiary contracts are those contracts that are designed between two or more individuals, but they're designed to grant a benefit to an outsider, someone who's not in privity of contract, not one of the contracting parties. Example of that is life insurance is the perfect example of it. I buy life insurance with Travelers Insurance Company, $100,000 policy. I pay premiums on it. Who are the contracting parties? I am and Travelers Life Insurance. But obviously, if it's a life insurance policy, it's designed to benefit a beneficiary. So I croak, I die. The beneficiary usually comes forward with a death certificate, and they get the money. They were never a contracting party. They never paid anything into it. But shouldn't the law recognize them as having a stake in it? And therefore, and they were clearly identified by both of the contracting parties to be a beneficiary, shouldn't they have rights? And the laws change. Yeah, of course they have it. But back in the common law, back in the earlier history of contract law, in order to really sue, to have standing, you had to be a contracting party. You had no rights. But this is obviously a silly principle, and it's changed under the Uniform Commercial Code and under other applicable laws in every state in the union. We do recognize there are certain third-party beneficiary contracts we're going to recognize. That's a classic one called the donee beneficiary. The book outlines the ones where you do have a right. Got to be very cautious about incidental beneficiaries. An incidental beneficiary is one that's going to benefit between the contract or the existence of a contract between A and B, but they were never intended to directly receive benefit from it. That's not the reason why A and B entered in the contract. I always think of the classic example. Say Bruce Springsteen, you guys don't know who Bruce Springsteen is probably anymore, but say a big musical artist is coming to the DCU Center in Worcester for 3 nights, a Thursday, Friday, and Saturday performance. If I owned a restaurant or a hotel near the DCU Center, would I expect to benefit greatly from the result of the contract between this big musical act and the DCU Center? Of course, but I'm what kind of beneficiary? I'm not an intended beneficiary. I'm not a creditor beneficiary or a donee beneficiary. I'm an incidental beneficiary. This comes up quite a bit. A business leaves a community or a business comes into community. We expect people to be hurt or benefited as a result of that, but we don't expect them to have the ability to sue over those contracting parties' breaches in the obligations flowing back and forth between the two of them. Incidental beneficiaries come up all the time. And I thought about it in my own law practice, for example. I don't do bankruptcy, but one of my associates at the time did when we were a team. And I was thinking about the boon of casinos coming into Massachusetts at the time. And I thought, boy, his bankruptcy practice is really going to go up big. And we actually had like an affiliated office not too far from Palmer, Mass. And one of the locations where there was an expectation that the casino might be in Palmer, Mass. And I was thinking even operating in the influence cases might become bigger as a result of this casino coming in just down the road from where our law offices were located. And of course, the casino didn't come. And my friend goes, "Oh, this is outrageous. So someone should sue." There's no sue. We're third-party beneficiaries. We were going to hopefully get a boon or a boom in our business just simply as a result of other parties' contracts. Those are incidental beneficiaries. They don't have any right to sue. And that comes up quite a bit. People feel like they're injured because of some non-performance on a or have privy to. So keep that in mind. Now, what's the classic ones that we have to go over? The one's a novation is a type of third-party beneficiary contract. I agree to buy your house for $300,000. One contracting party, you're the other contracting party. Now, what if along the way I decide, geez, I'm not really all that crazy about the house. I'm starting to have second thoughts, but I'm in a binding contract. What could I do? What if talking to other friends and things like that, I find out that your friend is interested in buying the house and you're willing to let me step out of the contract and you're allowing this other party, this third party, to step in my shoes. Now, if all three of us, you're the seller of the house, I was the original buyer, and now the new buyer is willing to execute that contract on the same exact terms allow me to leave all liability and escape all exposure under the contract, and the new person's going to assume all those duties with your consent. All three have to agree. All three of the original parties have to agree. That's called a novation. And they do happen a fair amount of time, but we don't always get lucky enough to have someone that's willing to take the responsibility or step into the shoes of the other party. Why is it important to recognize what a novation is? Because the original contracting party has no longer any obligations whatsoever. It's different from an assignment and a delegation, which is the bigger area of law. So let's start off with assignment. Assignment usually means about rights. So say I own a store and I allow some of my local customers to come in to buy things on credit. I take down their name. At the end of the month, they square up with me. It's a small little supermarket. They have a list and they write things down. And it's okay. You came in and you spent over the past month, you spent a few $100s at my store, but you didn't have money and you pay me at the end of the month. People don't do this too much anymore, but when I was a kid, my mother used to call a store and she used to actually place an order over the phone. Now we're doing it again with COVID, but back then it was common. She'd call up, it was called Galetti's Market. I never forgot it as a kid. She put in an order and a kid came over on a bicycle or a young person came over driving a car. They would deliver the goods. And I always remember the clerk would say, "Is this on your tab?" And my mother would say, "Yes, it is." And then usually at the end of the month, one of the store clerks would either call my mom to say, "Hey, I got to kind of square up on your thing," or she would just simply stop in the store when it was convenient and pay up her tab. Now, could Galetti's, the owner of that store, sell or transfer, if you will, assign the rights to collect that debt? Yes, and that's classically what it is. When you're talking about an assignment, it usually relates to the rights under the contract. And those are freely assignable by the parties unless there's something in the contract that say none of the rights are assignable in this contract. But rights we usually want to have freely assignable, and usually they relate to collecting of monies or rights to receive monies as a result of some events occurring in the future. We call the assignor the original owner of the right. We call the assignee the recipient of it. This happens a lot in banking, for example. I think there's some examples in your book. Say I take out a mortgage on my house. Basically, it's the loan. I owe Bank of America X number of dollars on a loan. Could Bank of America sell that loan and say, "Jim, you're no longer going to pay us the loan each month. You're going to pay this other group because we have assigned your mortgage to them"? Yeah, it happens all the time. It's sometimes a little bit controversial because you might get a loan with Bank A, and over the next 20 years, it might be assigned several different times. It doesn't change the terms that you have to pay. The amounts aren't any different. There's no difference in your obligation. It's just going to a different assignee. Be careful. Make sure you're paying the right entity and that the rights have actually been assigned and you're not getting a fraudulent a phishing scheme. And it's very common, especially in real estate transactions, to send out letters that, "We've taken over your mortgage. Pay us this month." And you do. And then all of a sudden the original mortgagee contacts you and says, "Oh, no, you still owe us. We never assigned your rights." Make sure it's done and the notification is appropriate. Notification isn't required at law, but you can demand it as the obligee. If you're the one that has to pay, you can demand it, but it doesn't effectuate the validity of the assignment from Bank of America to Hometown Bank. The notice is only upon if there's resistance of the obligor to pay or to perform, then you'd have to give notice. Delegation. This one's a little bit more complex. Say you hire me to do your divorce. Well, some types of duties to perform something has a personal element to it. You hire a lawyer because of their reputation, their skill, their experience, or a doctor, for example. Those kinds of duties aren't delegable very often unless the other party consents. But let's assume this. Let's assume you hire the Acme home painting company. They're going to paint the outside of your home. Could that painter then assign the duties to a subcontractor to paint your home? Yes, unless the contract said it was non-delegable. So duties, in most circumstances, unless it relates to a bond of trust and confidence and expertise, attorneys, doctors, therapists, things like that, most duties are delegable by the party that owes the duty. It's called subcontracting. It happens all the time. It's a great way to make money if you think about it. If I was a big painter and I had a really good reputation, I don't want to turn down work. So I'd probably take on a bunch of work and either hire employees to do the actual work or sub it out to other painters and make a profit. So if I was going to paint your house for $4,000, if I can find another quality painter for $3,500, I just made a $500 profit without having to do any of the work. Are there any obligations still flowing to me? Yeah, it's not a novation. I didn't step out of the contract. I stay fully responsible the performance of the duties to be done adequately and appropriately. So say that painter screws up and doesn't do a workmanlike job, that's sort of standard in the industry, reasonably decently done, which is Chapter 13, performance of the contract. Then you have a right not only to sue that party, the delegated party, but you also have the right to sue the delegator or the assigner of the duties. You can sue me because it didn't live up to the expectations. Now, the other end of it is, what if you're owed the duty? You hire me to paint your house, and I'm going to come out and next week and start painting, and you call me up and say, Jim, I decided to put vinyl siding in my house. There's this insulated quality and it's a permanency, and I decided I don't mind it. I want to have vinyl siding put in my house, so I want you to paint my cousin's house for the same price. That isn't how it works. You can't force someone to perform work for an employer or a contracting party that they didn't contract for. It's actually banned in theory by the 13th Amendment to the United States Constitution that bans slavery and indentured servitude. I could do it by consent. You can say, I'll go paint your cousin's house. I have a problem. But what could I say is, no, I had a contract to paint your house. You're breaching it. And the reason why you're breaching it is simply because you decided to go in a different direction. You don't have a right to get out of the contract. Now I can sue you for damages. It might not be the full contract price, but I can sue you for the amount of profit or earnings that I would have earned as a result of that paint job. So the party that owes the delegation can usually delegate the duty. The party that's going to receive the duty usually does not have the power to delegate it without consent. Notice of assignment of rights. So I owe you some money. You sell it to your friend. Your friend comes to my door and says, I'm here to collect the debt that Jane sold me. I usually want to have notice of that delegation of rights, but it doesn't affect the validity of it. So if Jane actually gave to Steve the right to collect that debt, that's fine. I can reject paying it until I'm notified by the original owner of that right. So notice isn't required unless demanded by the person that's going to have to satisfy the right, pay the money. So notice of assignment, effective assignment, form of assignment. I don't worry too much about that one. You should know that every assigner gives certain warranties, certain promises. So say I collect a bunch of debt at my office. I hate to use the law as an example because we don't like people assigning rights under law because it's just a thing, and it's not illegal, but it's just considered bad form. But let's assume I did a bunch of work for a bunch of different people, and I did it on basically you pay me later kind of a thing, and I have a bunch of accounts receivable. Can I sell those rights to a collection agency if I want to? Absolutely, I can. And I'm making certain promises when I sell those rights, certain warranties to the assignee. What warranties are? That I'm the true owner of the right. I have a right to this money. This person owes me $5,000, and I am the true owner of the right. The second one is it's valid and subsisting. I didn't just make it up. It's not garbage. It's a real debt that's owed to me. And the third one, and it's one of my favorite, there are known defenses to it that I didn't tell you about. So what if I said, hey, this person owes me $5,000. I did a bunch of legal work for him. I want to sell you that right. It's true and subsisting. I own it. I can transfer it to you. But what if I knew all along, maybe the reason why they're not paying me is I committed legal malpractice in my representation of the client, or I didn't perform adequately, or there were some problems in the way I informed it. So when they go to collect a debt, can they raise those defenses against that assignee? Of course they can. And they're going to be like, oh, now it's a non-collectible debt. So you have to inform them of any known defects in it. Now, careful. I might not think there are any defects in it. And just because they raise them later on doesn't affect the validity of my assignment. The assignment is valid. It's ones that I have to reasonably know about and inform the other party. Those warranties go in every assignment of a right. In this one, a lot of people get confused of joint and several contracts. A joint contract is if I have a joint contract with three people, each one of the three are legally obligated to pay the whole. I don't care which one of them does it, but if I have to sue, I can pick any one of those three to basically satisfy the debt. All have promised to pay the entire performance. Several is it's split between the three. You owe me 15 grand. Each one of the three owes me 5,000. That's a several contract, severed between the three. Almost every time we enter into contract, we always make the obligee, the one that's going to have to pay the money, joint in several. Why? Because that way I can pick and choose. I can make I can go through after all the whole group that owes the money, or I could pick an individual that wants to. It gives me a lot of protection because I said, yeah, I can get it from Steve, but Bob's going to be a deadbeat on this thing potentially. I want to be able to get the whole debt just from one of them if I want to. We do that in restitution and criminal cases, for example. You get 5 young people, they go do something stupid. A car gets damaged and the victim's out $5,000. We always make the restitution joint and several because we want the victim to get their $5,000. We don't care if it comes just from one defendant or from all 5, as long as the victim is made whole, if you will. So most contracts are joint and several. They're rarely just joint or really just several. They're joint and several. And you, if they're the one receiving the obligation, always want it to be joint and several. I know most of you find Chapter 12 very boring. I try to keep it short. But you should know about third-party contracts, that they come up quite a bit. Matter of fact, I don't know if it was on, I can't remember if I did it on this portion of the video, but I almost was completed before, and the thing shut down and I lost the video. But a classic example is credit cards. If you ever had a credit card and you fell behind initially, it's that credit card that's calling you, right? It's Capital One. They're driving you crazy. They call you all the time and say you're in financial woes. You're having some difficulty. So you ignore the debt for 2 or 3 months. All of a sudden, it's no longer Capital One calling you. Who is it? The Acme Credit Agency of America is chasing you down. What happened was Capital One probably assigned the right to collect that debt to that entity. And they did so with the warranties I just talked about, that they own the right of the debt, that it was real and subsisting at the time, and they knew of no defenses against the debt. And chances are they pay pennies on the dollar. There's a big business in this area. You can go out and buy, sometimes people call it buying paper. You can go out and buy debts that are owed by other people. There might be all kinds of problems with collecting them. They might be insolvent, they might file bankruptcy, and there might be defenses that weren't known to the assigner. But sometimes people say, hey, I'd rather get 50 cents on the dollar or 25 cents on the dollar, and they sell these debts. And if you're an aggressive creditor, a collection agency, I should say, you might be able to make a living basically being a credit agency that collects debts. I find it a bit repugnant. But I remember when I was first in court one day, and I always see this attorney stand up and this dentist, you call this dentist versus this, and he'd answer plaintiff on every one of the cases. Then some oil company would come up and they'd have a bunch of people that owed outstanding debts on their oil bills. And the same attorney would stand up and say, yep, I'm plaintiff. And I couldn't help asking him during the break. I said, geez, I said, you represent all these people. He goes, oh, no, I don't represent them anymore. I'm a creditor. That's what I do. I'm a debt collector attorney. All I do is buy debts that I think that are really subsisting on pennies on the dollar, if you will, and I go out and collect them, and and I make a decent living at it. I find it disturbing. I wouldn't want to do that, but there's an industry there. There's no question about it. And I kept it somewhat short. I hope that gives enough information for Chapter 12. I know it's a bit behind the scheduled posting of videos, but I'll get it up anyways, and I'm going to do 13 in a minute. Be well.